Good afternoon, everyone, and thank you for joining us for our expert speaker series today. We'll be presenting on Data Privacy Bootcamp with Jon Dartley. We are going to give people just about another 30 seconds to a minute to finish getting logged on, and then we will get started. So I appreciate your patience, and we will be right back. Okay, everyone, thank you again for joining us today for our Data Privacy Bootcamp webinar. This is hosted by JMT Consulting. We are an ERP and financial management solution specialist. We've been in business for a little over 27 years, and we specialize in nonprofits only. And on the next screen, you'll see all of our software partners that we work with. So if anybody has any questions or is interested in speaking with us more about our partners, we would love to chat with you offline. Just a couple housekeeping notes for you today on our webinar. If you have a question, there is a questions toolbox in your GoToWebinar panel. You can submit that question there. We are going to try something a little bit different today. If the question makes sense to interrupt Jon during the presentation, we are going to ask him. If not, we will wait and answer questions at the end of the webinar. Also note that today's webinar is being recorded, so we will email that recording to you along with a copy of the slides tomorrow. And with that, I'm going to introduce Jon Dartley. He is our speaker today. Jon Dartley founded and operated Involve Inc., the web application development and design firm that pioneered online peer-to-peer fundraising, list building, and advocacy campaigns for nonprofits. Involve was acquired by Kentera Inc., a leading cloud software provider to nonprofits. When Blackbaud acquired Kentera, Jon was named Senior Deputy General Counsel and Information Governance Chair. In addition, Jon has had more than 15 years of experience representing nonprofit organizations in a wide variety of business matters and legal transactions. He has extensive knowledge in matters relating to privacy and big data, technology, outsourcing, software, intellectual property licensing, internet-related transactions, general corporate matters, and venture-related funding. We are thrilled to have him today, and with that, I will turn it over to Jon.
Thanks so much, Melissa, for the introduction. Hello, everybody. It's a pleasure to be here, and I'd like to again thank JMT for providing the opportunity to speak with everyone today. And I was mentioning to Melissa, I know we're competing with the Michael Cohen testimony, so I'm going to try to make this hopefully just as interesting and riveting as I'm sure that is as well. Privacy and cybersecurity are, as you know, increasingly becoming an important public concern. It seems that hardly a month goes by that we don't hear about some sort of large-scale data breach. And of course, the fact is that there are smaller, non-publicized breaches occurring every day. And from my observation, nonprofit organizations, at least in the past, have often been far behind for-profit organizations in terms of making privacy what I would call like a C-suite or a top priority, a top concern. This is unfortunate. And the reason I'm really constantly proselytizing on this issue is that the damage and negative consequences that a data breach can have on a nonprofit organization can be immense. So, for example, if you were a long-time donor to a nonprofit and just learned that your credit card details were provided to a hacker, how would you handle working with that nonprofit in the future? In an article recently, N10, which is the nonprofit technology network, an author pointed out that when nonprofits experience a breach, the ramifications, the detrimental ramifications are often much harsher as compared to for-profit entities. The fact is, a lot of consumers, when you're working with a for-profit company or a government organization, it's hard to go elsewhere. But studies have shown that in terms of with nonprofits, that a donor, if they feel like their data has been breached, will be more likely to donate to a different organization the following year. So considering the risks, the reputational harm, the fines, and even the potential for civil and criminal liability that a data breach can have, today I'm going to try to provide a framework, a boot camp of sorts, for both what you must know and what organizations should do to hopefully minimize the risks and specific actions you can take to minimize risks. So as you see on the first slide, every year, not surprisingly, the amount of breaches grow. The number of records that are breached doubled to 446 million last year alone. And a study by Perlman Institute estimates that data breach is occurring not only all the time with organizations, but that the costs are rising. And nonprofits are not immune. In fact, nonprofits are often the target of hackers, specifically because they often are not as sophisticated and don't have in place a lot of the mechanisms that the for-profit entities have to protect against data breach. Well, they're considered what they call soft targets, and more nonprofits are being targeted. So just to kind of start the conversation, when we talk about data, what the data we typically care about is what we call PII. You'll hear that a lot, personally identifiable information. So what is PII? PII is any data that could potentially identify a specific individual. Any information that can be used. So we're talking about a name with an address, phone number, donor history can often be PII. There's either sensitive or non-sensitive. Think about non-sensitive PII as information that can be easily gathered from public records, phone books, directories, websites. Sensitive PII, on the other hand, is information publicly available, but when disclosed could result in harm. So we're talking about information related to health, information related to financial history, credit card information, the type of things that nonprofits often have are both PII and what we call sensitive PII. Going forward, I'll just talk about personal. What we're really concerned about is anything that's personally identifiable. So why is protecting PII important? Well, as you all know, it's a valuable organization asset like any other. It's a high risk for theft because it has value to people, and the loss of PII can be long-lasting. It's reputational harm to your organization, loss of donor trust, often and increasingly financial penalties and costs, and of course legal liability. And many organizations have obligations to protect data. There are many laws and regulations and guidelines. There's contracts with third parties. There's your privacy policy. So for a variety of reasons, you want to try to put in place precautions against having the PII breached. So the objectives of this bootcamp is we're going to do a few things. Hopefully, we're going to talk about your website privacy policy and make sure that that's in shape. We're going to give you a framework to understand your organization's data gathering practices, so you know what kind of data you're getting, why you're getting it, and how you're protecting it. We'll talk a little bit about major cybersecurity risks and strategies to mitigate. We'll look at cybersecurity insurance, which hopefully everybody has, and if you don't have it, we'll talk about some key things and key terms you want to have in your policy. We'll talk about adopting a disaster readiness and response plan. I say it's when bad things happen to good people, you still need to be ready. And then we'll talk about some applicable privacy laws that your organization, if you're not thinking about now, you should be thinking about in the future to comply with. So, first step is have a website privacy policy. Most organizations have them. What I often find is if they have them, they drafted once, it's been posted on the website for many years, and it hasn't changed. A website privacy policy is really the legal document that discloses all the ways your organization gathers, uses, discloses, and manages donor data collected online through your website. This is not something to take lightly, especially in these days in which organizations are using and protecting data is getting increasing attention, and especially considering the increasing sensitivity that individuals have and how their data is being used and shared. So your nonprofit needs to follow the policy by implementing necessary security measures to protect the data you have. So basically, I look at a privacy policy as a promise to your donors and about transparency. You're promising that you're going to do certain things with their data, and you're telling them about it, and you're being transparent. in terms of crafting a privacy policy, there are a few things you should keep in mind. You want to write the policy in clear, simple English. No need for legalese, and that's the lawyer saying that. You should, in all instances, talk about the personal information you're collecting on the website. So if someone makes a donation, let them know you'll be collecting the credit card information. You'll be collecting their name, their address. If somebody signs up for an e-newsletter, you want to be clear. You'll be collecting their information. If somebody needs to register on your site to get access to certain information, be clear in all the ways you're collecting PII. Also talk about how you're sharing the information. Partners, affiliates, list sharing. You want to list out all possible scenarios in which their data may be shared. One of the reasons to do that is if there's a breach of their data and it doesn't come from your organization, but it comes from a third-party partner, folks would be very upset if they weren't aware you were sharing that data. Make sure you address the applicable laws that apply to your organization, depending upon, obviously the state you're in, the work you do, whether you're international or not. Address third-party links. If you're linking, which most websites do to these days, at the very least you link to various social media sites. You should talk about the fact that when people go to those sites from your website, they may be asked to provide personal information. Your organization is not responsible, but they should read the privacy policy of those sites you're linking to. And then we'll talk later if GDPR address applicable laws. I mentioned that in GDPR. We'll talk about that's the General Data Protection Law. It does affect almost every nonprofit. And if it does affect you, you need to have specific language in your privacy policy related to GDPR. And finally, don't forget you should also have the terms of use. While a privacy policy is about transparency, the terms of use is about retaining your legal authority to basically enforce obligations on the website. So you want to have both a privacy policy and terms of use. If you have a privacy policy, it should really be reviewed and updated every year. Like I said, many organizations have a privacy policy. It was drafted 4 or 5 years ago, or 6 years ago, whatever the time frame might be. The fact is, as you know, if you're operating a website, the online data gathering practices change all the time. You have new partners, you share data in different ways, you may collect data in different ways. You need to make sure your privacy policy is staying up to date. I guarantee if you haven't looked at your privacy policy in the last few years, it's probably not up to date in terms of the practices that you're taking. Okay, so first step also in terms of the boot camp is what I call the PII audit, personal information audit. It really helps to assess your risk. As mentioned, data privacy breaches are increasingly common, and the potential negative consequences to your organization in terms of reputational damage, potential liability, costs, fines are increasing all the time. To avoid these consequences, organizations that collect, use, or transfer any personal information should do a PII audit at least once every few years. What is a privacy audit? Basically, it doesn't need to be expensive. It doesn't need to be too time-consuming, but it's looking at all the data you have, what data your organization collects, and what. Why is the data being collected? Many organizations collect much more data than they need, so it's looking at why you're collecting the information you're taking. Who has access to the data? So it's not just internal employees, but who are the vendors you're working with? Who are the consultants that might have access to the data? Where is the data being stored? When is the data being deleted? And how is the data being protected? Typically, a privacy audit is comprised of a variety of questions that I provide organizations depending upon the work they do. For example, we talked about what is the purpose for the data being collected. For example, donor administration, employee administration, advertising, marketing. What individual's personal data is being processed. For example, is it donor data? Is it employee data? Is it supplier data? The types of data being collected. So is it just home? Is it just names with home addresses? Is it telephone numbers? Is it social security numbers, credit card numbers? Get a sense of all the information you're collecting. How is it being collected? Is it come through? Do you have hard copies that you keep? Is it coming from telephone? Is it all online? Is it coming from partners? Do you have the proper consents? So when you're collecting information, you want to make sure that the individuals who are giving you the information realize that the information is given you, how you're using it, and they've opted in for that. How relevant is the information you're collecting? Again, we've talked about why. Again, most organizations collect more data than they need. The more data you have, the more risk you have as if there's a breach. So you want to make sure that the data you're collecting is for a good and valid reason. How long is personal data being retained? Is the retention period really necessary? Meaning, is it legally mandated? Is the data still useful? We'll talk about this a little bit later, but really, you only want to keep the data as long as it's useful. The more data you keep, again, the more risk you have if there's a breach. Where and how the personal data is being stored. This is where you want to look at vendor agreements. You want to look at employees. If they leave, are they shut out of access to the information? The organizational and technical measures, you want to figure out in the organization in terms of how is the data being protected. This is typically working with either an internal or external IT person, but just making sure the data is protected in the right way. And then again, if you're disclosing any kind of your personal data to third parties, understanding the agreements you have with those third parties, making sure that you have the right terms in place to protect the data, and the right terms in place that if something goes wrong, those partners do the right thing. And so the benefits of conducting a PII audit is it shows that you're serious about privacy and data security, but studies have shown that organizations that do a PII audit dramatically reduce the risk of having a breach, whether inadvertent or through hackers. And of course, it heightens the accountability that the organization has in terms of privacy matters. Okay, so other things we can do to kind of mitigate the cybersecurity risks. Keep it safe. Train employees about safe practices and provide them with a written policy. Most organizations I deal with don't do training. If they've done training, it was many years in the past. Training should really be an annual thing, so employees know exactly what's expected of them and how to treat the data, how to protect the data. Implement, things like firewalls, passwords, antivirus software. I cannot tell you how many organizations have experienced a breach and could have been avoided by, taking these simple steps. Obviously, everyone should have a firewall. Antivirus software is a great example. A lot of organizations just fail to kind of update their antivirus software, and often breaches happen that could have been avoided. Use extra caution when it comes to laptops, cell phones. To the extent to which any employee or volunteer has PII on any of these devices, they should be encrypted. You should have a policy in terms of how people, protect these things, whether they can take them out of the office, how they store them. Make sure that if you have physical records, this is a simple one, make sure that the desks and drawers and closets are locked. Limit access to any kind of sensitive files to people who have a need to know, and destroy what you can. So you should have a data retention and a data destruction policy. When the data is no longer useful, get rid of it. Next one, to mitigate the cybersecurity risk, is focus on vendors. Third-party vendors is probably the biggest cause of data breaches. Most organizations increasingly are moving to the cloud. Very few are hosting their own servers. If you're like most organizations, you're working with at least a variety of different third-party vendors who either have access to or host your personal information. So when you review these agreements, when they come up or when they come up for renewal, when you're entering a new relationship, there are certain terms you want to have in every agreement. So, for example, representations and warranties. These are the kind of the special promises that the vendors make to you in terms of things they will do. Typically, they're very scant in these agreements, and you need to basically insert a number of promises as it relates to privacy, cybersecurity, and a whole host of other things. Privacy security specifically, as you need to make sure that the vendors have specific physical, administrative, and technology protections in there. I will literally sometimes add a page or two of additional language into these contracts, promises that the vendors are making in terms of the specific tasks they're going to take to protect your information. The indemnifications, you want to make sure that if there is a breach, your nonprofit is covered. Right? So indemnification is a special promise to pay for your damages. It needs to be in the agreement. In regard to limitations of liability, as you know, all agreements try to limit the liability. In any vendor agreement that you're negotiating, you want to make sure you have a carve-out, which means an exclusion to the limitation of liability for the very least for a data breach. Because when breaches happen, the cost can be astronomical, both in terms of credit monitoring, in terms of legal costs, in terms of regulatory fines. So you need to make sure that that's a carve-out to your vendor agreement. Also, I'd like to have some specific breach notification language in there. So when there's a breach, the obligation for the third-party vendor to notify you within 24 hours, to provide you certain information, to work with you, and of course to pay for all your any kind of legal costs you might have. And finally, in any vendor agreement, you want to make sure you have transition services. If it comes time to leave that vendor because they're not performing the way you'd hope, there's a better vendor out there for your organization. You want to make sure that the vendor is on the hook for making sure that they work with you and make a smooth transition. When I talk about vendor agreements, I always like to add the anecdote that for a number of years I was the Senior Deputy General Counsel at Blackbaud and really wrote all their agreements. And now, from time to time, I have the opportunity of being on the other side and representing our nonprofit clients in negotiating these agreements, especially the Blackbaud agreement. And I'll often add 4 or 5 pages of additional text. And at one point, the General Counsel said to me, "But John, you're editing the agreement you wrote." I said, "Yes, but now I'm on the other side." And the reason I bring this up is because depending upon whether you're the vendor or whether you're the person using the vendor services, the types of terms you want are radically different. And most vendor agreements are very one-sided. It's not just what's in the agreement, it's things that should be in the agreement that are not there. So it's very important with any kind of third-party vendor agreement, anyone getting access to your personal information, either your donors, your employees, to really vigorously negotiate the agreement to make sure your organization is protected. Now, I often get the question that what happens about the agreements we have in place? Well, as part of the PII audit, one of the things you should be looking at, and you can do this yourself, is pull out every vendor agreement that you have that has access to your personal information and look at those terms. If you can't renegotiate because the agreement's is current, typically all agreements have auto renewals. Put on your calendar when you have to give notice of termination before the auto renewal. Do that and then negotiate the agreement anew. All right. Next one is, and we talk about data retention and destruction policy. I mentioned it earlier. Very important. Very few organizations have it. Every organization should have it. Basically, it's a policy of what data you're retaining, why are you retaining it, and how long you're keeping it for, and then how do you destroy it. So first step is get organized. And any retention policy is just get a sense of the data you have. Where is it? What kind of data is it? How long are you keeping it for? The next one is get informed. There are certain laws that apply to how you keep data. IRS data, for example, 7 years. Employee data, depending upon the state you're in, varies as well. But you want to make sure that you're complying for certain types of data with the laws that apply. Next one is backup. Make sure for anything that's important, any PII, anything that you're actively using, that you have backups. This could be either through a third party or you're doing it in-house. And then get destructive. At some point, you don't need the data you have. It could be a donor who's left and hasn't donated for several years. It could be employees who've left. When you no longer need the data, get rid of it. If there is a breach, the more data you have, the more costs are going to occur. The next one, big one, is cybersecurity insurance. If you have it, great. You should look at the policy. If you don't have it, you should get one. Cybersecurity insurance is a robust insurance policy. It can really help your organization weather the storm of any kind of data breach or data incident. Unfortunately, most don't understand the scope of the policy, so you need to make sure when you negotiate the policy with your broker that you ask for certain things. So, for example, every cybersecurity policy should have data breach liability. This coverage will defend your organization against legal claims. A typical suit will allege that your nonprofit was negligent in failing to protect the information that you have, and you want to make sure that the insurance policy will cover you for those costs. Data loss. Your current property policy probably covers damages to computers you own, but traditional policies do not cover any kind of data, digital data that is stored on those computers. Most cyber liability policies do cover loss or theft of PII. You want to make sure you have money in the policy, protection in the policy, I should say, for forensic investigations after a breach. Notification costs of communicating the breach. This is a very big one. Almost every state has notification requirements for both private and governmental entities as well as nonprofit. If a data breach occurs to your nonprofit, it is likely you will be required to provide notice to all the donors who have had the data breached. Important to keep in mind, your vendor has an obligation just to contact you. You have an obligation to contact all of your donors. One of the reasons why, and when we talked about the vendor agreement a couple slides before, is you want to make sure that if there's a data breach, that your vendor will cover your notification costs. Credit monitoring, often required, is now required as the best practice. You want to make sure your policy will cover that. Even public relations, expenses, and crisis management. After a data breach occurs, there'll be a variety of things that you'll need to do. A good cybersecurity insurance policy will cover this as well. Then there's a lot of third-party costs, legal defense, settlements, liability to banks if credit cards need to be reissued, regulatory fines. Make sure the policy covers that as well. And just as another anecdote, I was a few years ago asked to review a cybersecurity insurance policy that a very large nonprofit had. They were paying a lot of money for it. And when I reviewed the policy, I realized it was actually drafted as if they were a third-party vendor providing services as opposed to a nonprofit working with third parties. So had there been a breach, this particular nonprofit would not have been covered because the policy just wasn't applicable. So it's important to have a policy. It's also important to read the policy and, again, negotiate the policy to get the best terms you can possibly get. Okay, so other things you can do is specific data security strategies. We talked about a few before. One is ensure you have regular software updates. Make sure that the IT staff or your contractors are installing security patches and updates to your devices, operating software, and other software. Oftentimes, as I mentioned, data breaches occur when software is vulnerable due to the age, outdated software, or other issues. Software updates typically include new security measures that will help protect your device and data against loss. Encrypt sensitive data. If a theft of a laptop or mobile device constitutes a data breach, probably if your employees or volunteers have PII on them. So consider encrypting any device that has personal information on it. Schedule data security training. We talked about this. By the way, some cyber liability policies will actually pay for training, but you want to make sure that you cover a variety of things, including bring your own device policies. If someone's using their own device, what they should and should not put on that device. Network security protocols, changing passwords, encryption instructions, relationship with tech vendors, data breach notification laws, all the things employees should know in order to protect the data you have. And in terms of having a bring your own device policy, if you allow employees or volunteers to bring their own device to work and put PII on there, you need to have a policy in place to kind of teach them and educate them in terms of the kind of do's and don'ts. Next one, kind of to mitigate, is to know the laws that apply to you. Various federal and state data privacy laws govern organizations' collection, use, and sharing of individuals. Also, there are a variety of other regulations. There's, the PCI, which is the Payment Card Industry Data Standard, which hopefully applies to your vendors and not you, but for many organizations, if you're actually hosting some of the information, technically it can apply to you as well. Also, 47 states, including District of Columbia, Puerto Rico, Virgin Islands, have enacted laws that require organizations to notify individuals if there's a security breach, so you need to be aware of those. And then vital to understand any other kind of local laws that might apply. And speaking about laws, GDPR is one that many of you probably heard about. By now, it's a general data protection regulation. It's at its core. It went into effect, by the way, in May of 2018. At its core, GDPR sets new rules designed to give EU citizens more rights over their data. It aims specifically to regulate U.S. entities in terms of how they deal with the data collected from people residing in the EU. Odds are, if you have a website, GDPR applies, because people from the EU are accessing your website. They may be providing you information, and from an EU perspective, GDPR does apply to your organization. GDPR is a game changer. It basically offers a new paradigm, or creates a new paradigm that both for-profit and non-profit organizations have to follow. It redefines what traditionally has been considered to be protected information by broadening the concept of personal data to anything that can be used to identify a person, including email addresses, Twitter handles, and even an IP address is considered to be PII. The key public policy maintains that data belongs to the people who give it to you, and that they retain certain rights as long as they're using that data. The basics, again, went into effect on May 25th, 2018, covers processing of any personal data of anyone residing in the EU, and the fines are immense. It could be up to 4% of your organization's revenue or 20 million euros, whichever is greater. So, often asked, does GDPR apply to your organization? And the short answer is typically yes. As I mentioned, technically GDPR applies if anyone is accessing your website from the EU, from the UK, from Switzerland. Practically speaking, you probably don't need to be concerned about GDPR if you're not collecting or holding any PII from the EU. Meaning, just because your website is accessible, that's fine. But if you are starting to collect information, then you should abide by GDPR. Keep in mind, by the way, GDPR is probably a foreshadowing of what's coming to this country. There are many states looking at enacting similar regulations, and on the federal level, we're likely in the next year or so to enact something that would be similar to GDPR. But I advise organizations that even if GDPR doesn't apply to you, by kind of taking it seriously, you'll just find that you'll be better stewards of the data you're collecting on behalf of your donors. So let's assume GDPR does apply, as it does for most organizations. What do you need to do? One thing is you need to immediately update your website privacy policy. And we talked about being current and every year to review. This is a great example. GDPR requires specific information, and specific disclaimers, and specific language in your privacy policy. I call this kind of low-hanging fruit, that if a regulator or somebody was concerned about you complying with GDPR, the first thing they're going to do is look at your website privacy policy. If you don't have those kind of special words in there, you'll be in breach of those obligations. Vendor contracts, very important now to look at. That basically GDPR imposes that you have specific terms with your vendors. These terms mirror the promises that you're making to people residing in the EU in terms of what you need to do with the data, which we'll talk about a little bit more in detail. But you need to make sure these vendor contracts have specific provisions in them. In terms of consent, I know a lot of organizations use the opt-out. Opt-out is no longer something you can do. It's the new. I would say the new opt-in is the old opt-out. It has to be opt-in. It has to be an explicit opt-in. So you need to be careful about that. Again, it's kind of low-hanging fruit. If someone goes to your website and sees that you have an opt-out, right away they know that you're not complying with GDPR. Limits on data retention. We talked about having data retention policy. GDPR specific provisions of how long you can keep data. Certain things, by the way, people have the right to be forgotten. So somebody can contact your organization from the EU. So you have the right to know the data you have. They have the right for portability. So you give me all the data you have on me, and they have the right to be forgotten. So you actually have to specifically delete all the information you have. So there are a variety of obligations with GDPR. You need to make sure you're complying. And again, as I mentioned, you need to make sure that the vendors you're working with comply as well. This is very important because if you get some sort of GDPR request, you need to be able to make sure your vendors are willing and able to kind of promptly reply on your behalf. And that's it. I know I've gone through a lot of material here. So if there are questions, I'm happy to answer them. One thing I will tell you that I know Melissa will be sharing some these slides with you with some other additional information. I do have a GDPR kind of questionnaire and checklist. If you think GDPR applies to your organization, email me. I can provide you something that can help you start thinking about how to comply. And with that, I will turn it over to Melissa and see if there are any questions. Melissa? I see one question here. No, that I don't see it. Yeah, sorry about that.
Can you hear me, John?
Oh, now I can hear you.
Okay, I'm sorry. I'm having issues with my headset, so I had to go to speakerphone. I apologize, everyone. So we do have a few questions. So first, you've covered a lot of ground here today. If you were going to prioritize a few immediate steps for an organization to take, what would those be?
Good question. So, yeah, in terms of immediate steps, one is, obviously look at your privacy policy. If it hasn't been updated in the past 12 months, and certainly if GDPR applies and even it has been updated, but it doesn't cover GDPR, address that. Vendor agreements, I'm always, I feel harping on this issue with my clients, but, these are typically the way your data is going to be breached. So you need to kind of really get a handle of all the vendors you're working with, look at those contracts and make sure, obviously when new ones come up, but even with old ones, before they order renew, negotiate those terms, get certain terms in there that will protect your organization. And I guess the third, if you don't have a cybersecurity policy, get one. And if you do have one, review it and make sure that it has the right things in there to cover your organization, that there's certain things aren't excluded that would not cover you. And again, I know there's a couple agents that I refer clients to who kind of specialize in working with both nonprofits and on cybersecurity. So if anybody has a need, they can feel free to shoot me an email and I can make that connection.
Excellent, thank you. Also, you mentioned that third-party vendors are often the cause of a data breach. So given that, what would you recommend the organization do differently going forward?
Yeah, so I think I touched on it a little bit. Is these agreements really need to be looked at closely. They need to be negotiated, very aggressively. And I just say that knowing that the agreements you get, being on the other side, as I said, being at both the Blackbaud and the Terror and organizations like that, the agreements are drafted, obviously and not unfairly to favor the vendor because it's their agreement. So they need to be negotiated. All vendors negotiate their agreements. I know I hear clients sometimes say that no, they said they couldn't make any changes. You can always make changes, and often many changes, especially when these vendors are getting access to your personal information. They know that, they expect that. Again, it's not just what's in the agreement, it's also the things that should be in there that aren't. So you need to be, cognizant of the things you need to add in there. Something I put in every vendor agreement that deals with PII, every vendor agreement is if there's a data breach, they'll cover your costs. I've actually never had a vendor say no to it. I've had them say no in the first draft. I've had them maybe say no in the second draft. But when it comes time to sign, I've never had a vendor not agree that if there's a breach and they're the clause, that they won't cover your cost. That's a huge thing to have in a contract because it can save your organizations, certainly tens of thousands, if not hundreds of thousands or more every year if there's a breach during that term. Also, make sure one of the things in these vendor agreements is the limitation of liability. Almost every vendor agreement comes to you with a 6-month or a 3-month cap on damages. You need to make sure that you obviously broaden that cap. But for things like data breach, data loss, there can't be a cap for direct damages. So you need to make sure you look at that as another example.
Got it. So there seems to be a lot of hoops to jump through for an organization to be able to comply with GDPR. Do you have a recommendation for how organizations should approach compliance?
Yeah, and I would say GDPR, when it came into effect, I've never had so many organizations, call me and say, what is this thing and what do we need to do? And I know I always start out often when I talk about GDPR is, the good news and bad news. The bad news is GDPR is here. I also say the good news, GDPR is here. In a sense, GDPR makes us better citizens. It makes us better stewards of the personal information we're collecting on behalf of organizations, on behalf of our donors. So even if GDPR doesn't apply, but it probably does, but even if it doesn't apply, by starting to think about privacy in a proactive way, it's better for the organization. Now, if GDPR does apply, which it does to most nonprofits, you need to get a handle on the data you're collecting from the EU. You need to, again, update your privacy policy. There needs to be specific language and disclosures in there. You need to revise how your what we call an explicit opt-in is no longer are you entitled to have a very general opt-in or an opt-out that's considered illegal. Not only that, if your opt-in is not very specific, it's not considered valid. There's no grandfather clause. So I've dealt with a couple organizations who had thousands of names from people in the EU. It's not like they're grandfathered in, so if they didn't collect the information the right way, they have to go back to these people in a very specific way to ask for permission to continue using their names. So that's important. The other really big piece of GDPR, which I touched upon, is third-party vendor agreements. You are now obligated. You're legally, by the way, liable for any actions your vendor takes under GDPR. It's as if you did it yourself, and you're legally obligated to make sure you have certain provisions, what I call certain promises, with every vendor that they'll basically do certain things if requested. So those are certainly like the top 2 or 3 things that right away you need to do if GDPR applies to your organization.
Thank you, John. We did have somebody ask if we would share the slides, and yes, this session is being recorded, and we will be sharing the slides with everyone. Be on the lookout in your inboxes tomorrow for that. We don't have any other questions right now, so we'll give it just another minute or so for people who want to ask questions. Remember to do so, you type the question in the chat portion of your toolbar, and that will come through so we can read them and John can answer.
Yeah, and I think I mentioned this earlier, but people often questions come up later or next week, or someone remembers the seminar and something comes up across their desk. People can feel free to email me or reach out to me if they have questions after this. I'm happy to either hop on a phone or answer by email with a simple question.
Wonderful. We'll see if any more questions come in. And if not, we'll let everyone go back to their day. John, it looks like we are all set with questions. So with that, what we'll do is I want to thank everyone for their time today, and John for his time telling us about cybersecurity and Bootcamp. If you, like you said, if you have questions, you can also respond to the email that we send tomorrow with the slides and the recording, and we can get you in touch with John. You can also visit jmtconsulting.com and click on our events tab to find out more about webinars like this that we host, as well as live events. But with that, again, I want to thank John and thank you everyone for your time. Have a good day.
Thank you. Bye-bye.
Bye.